Let's talk a little bit about trusts. Now, you've probably heard this term before, but you may not be familiar with what it is. Sometimes you hear about someone who's wealthy and their children have money in a trust, maybe the Kennedys or Paris Hilton. You know, they have trust funds. And you hear this term a lot, but what exactly is it? Well, a trust is a legal entity that holds and manages the assets for another person. And it's created when an individual, known as the grantor, transfers property to a trustee for the benefit of one or more people. So that trustee has the responsibility of carrying out the wishes of the grantor. So they don't have access to the money to do as they please. They're supposed to handle the money as the grantor specified. So why would you create a trust? Well, one reason is to avoid probate. Now, you may be familiar with the concept of probate. Probate happens after somebody passes away, and their estate, some of it may be subject to probate. And you have to go through court proceedings, and you have to make this information public. Trusts do not go through the probate process, so that's one advantage. Trusts are more difficult to challenge in court than wills. And again, on TV, sometimes you hear about wealthy individuals challenging a will in court that they left too much money to this third spouse, or they didn't leave enough to the children, or someone wants in. Well, setting up a trust is more difficult to challenge. Trusts can reduce estate taxes. So when somebody passes away, they have estate taxes. If you've set up the correct kinds of trusts in the correct way, you may be able to avoid some estate taxes. It allows for professional management of the money. It provides for confidentiality. Again, a trust is not made public, but in the probate situation, that information is a matter of public record. It goes through the court system. So if you have assets that you don't want others to know about, a trust may be a good way to do that. It's a good way to provide for a child with special needs. If you happen to have a child with special needs, when you pass away, you can't just hand that child lots and lots of money, even if they happen to be 30 years old or 40 years old. They may not be capable of handling the money, so you may put the money into a trust and have a trustee manage it for them and dole out what's needed for their living expenses. You can use this to hold assets until a child reaches maturity, 18 or 21, depending on the state. Again, if two parents were to pass away and they had minor children, again, you can't hand, or you wouldn't want to hand, a 12-year-old and a 6-year-old perhaps millions of dollars. So the money gets put into a trust, and the trustee manages that money for them and doles out, the appropriate amount of money to take care of their living expenses, to pay for college, etc. And it may be a way to ensure that children from a previous marriage will receive some inheritance. So if a person marries again, you don't necessarily want all the money to go to that spouse. You may want that spouse to be taken care of until they pass away, and then the remainder goes to your children. So here are a few different types of trusts. You can have living trusts, and you can have a revocable living trust. This is the case where a grantor places assets into the trust while the person's still alive and can withdraw the funds later if he wishes. That is, it's revocable. So if this person decides that he doesn't like how it's set up, he can dissolve the trust. So there's not really much difference between outright ownership and a trust while the grantor is alive, but once the grantor dies or becomes incompetent, the trust takes over and starts managing the assets. What are the advantages? Well, it avoids probate upon death. The individual, in the case of a revocable living trust, maintains the power to alter or cancel the trust. If the individual becomes incompetent, the assets will continue to be professionally managed by the trustee, and the trustee can also be replaced. Some of the disadvantages: there's no tax advantages in this type of trust. The individual pays taxes on income and capital gains on the assets in the trust. The assets are considered part of the individual's estate for estate tax purposes, so that's not going to save any estate tax. And the assets cannot be used as collateral for a loan. Now let's compare that to what's referred to as an irrevocable living trust. This is permanent and it can't be changed. So once it's set up, the grantor can't change it. So in this case, the individual no longer has title to the assets. The trust has title to the assets. And this can actually be a good thing. Sometimes you'll hear about an older individual who has to go into a nursing home. They may not have a tremendous amount of assets, and sometimes they sign away their house to the nursing home. And if they live for another 15 years, the nursing home takes care of them. If they happen to pass away in 6 months, the nursing home still gets the assets, or they can come after those assets, gets the house. If it's in an irrevocable trust, subject to certain regulations, it has to be set up far enough in advance. That doesn't belong to the person. So that, the person or the, for example, nursing home can't come after those assets. The trust becomes a single legal entity and pays taxes on the income and the capital gains. And because these assets aren't part of the estate, any appreciation of the assets would not be subject to estate tax. So if a grantor put $1 million in some sort of living trust and the assets grew to $5 million, that extra $4 million would not be in the estate of the individual because the assets are no longer in this person's name. They happen to be in the name of the trust. What are the advantages? Again, avoiding probate. As I mentioned before, price appreciation on the assets in the trust is not considered part of the individual's estate. No estate taxes are imposed upon them. So, again, very good for estate planning, especially for someone who's wealthier. Income earned can be directed to the beneficiary, which can result in lower taxes if the beneficiary is in a lower tax bracket. What are the disadvantages? The individual no longer maintains control of the assets in the trust. The assets in the trust cannot be used as collateral on a loan. It can be very expensive to set up this, and it can be more expensive than the probate costs. So if you're doing this simply to avoid probate, okay, it may not be cost effective. And it can involve a lot of paperwork to set up a trust like this. You can also have testamentary trust. And this is one that's created by the will. And it doesn't exist until probate is completed. Now, there's something referred to as a standard family trust, and there are different categories, sort of AB trust, credit shelter trust, unified credit trust, but they're all kind of the same. And the primary objective is for married couples to ensure the estate tax exemption of the first spouse to die could be used by the surviving spouse. So assets of the first spouse do not become part of the second spouse's estate. So, for example, I believe as of this, as I'm making this video, the standard exemption is $5 million per person. Let's say a couple has $10 million in assets, and the husband passes away. If he passed that $5 million on to his spouse, now there would be no estate tax implications because you can pass an unlimited amount to a spouse. But now she would have $10 million in her estate, and if she passed away shortly after, then she could exempt, the estate could exempt $5 million, but the other $5 million would be subject to estate tax. Now, if the husband were to pass this money into a trust, it's not in the spouse's estate, and therefore, when she passes away, she can use her $5 million exemption. The trust has used, or the husband has used his $5 million exemption by passing it to the trust, and so they've managed to pass along $10 million without any estate tax implications. So this can be very useful for people who have a lot of assets. A couple of other types of trusts. you can set up an irrevocable life insurance trust. And this allows a wealthy individual to keep the life insurance, which can be a major asset, out of her estate. So if an individual has, a very large estate, and perhaps she has, a $5 million life insurance policy. Well, she doesn't want that in her estate, so she sets up this irrevocable life insurance trust, transfers the policy into the trust, and therefore it is out of her estate. Usually the trustee is named as the beneficiary, and the terms of the trust enable the trustee to use the proceeds to pay the grantor's estate taxes and to care for the grantor's spouse and children. And the last type of trust I'll mention here is something referred to as a Crummy trust. And this was named for the first person to successfully use this trust structure. The reason it's used to make tax-free gifts up to the annual exclusion amounts to children. So again, as I'm making this video, I believe that exclusion amount is $13,000. So were a parent to give their child $13,000, let's say the child is 10 years old, well, you probably don't want that child to have access to spending that $13,000. But the law requires that you can't just use that exemption, okay, reduce your estate size by giving this $13,000 with no gift tax and not allow the person to use it for 20 years, so, or 10 years or 5 years. So what happens is this money is perhaps put in a Crummy trust, and the Crummy trust gets around this restriction of allowing this child access to this money by allowing the beneficiary to withdraw money for a limited period of time, maybe 30 days or so. And if they don't withdraw any in that time period, they can't withdraw any. So, someone with a large estate that wants to start giving away some of their money but doesn't want to pay gift tax can give money to a child, and again, they'll have just a short window to take the money out, and the money will, but they'll still get that tax, that exemption on they don't have to pay gift tax. So you can see that there are a number of reasons for setting up trusts, but it can be very important in estate planning in terms of avoiding estate tax, or again, in terms of taking care of minor children. Nobody wants to give their 9-year-old, hundreds of thousands or perhaps even millions of dollars because they're not going to know what to do with it. So you put it in a trust, the trustee manages the money, makes sure the money gets doled out to them for appropriate living expenses, such as college or paying for private school, whatever the case may be. But this is a really powerful tool. There are a lot of different kinds of trusts. It can be very complicated, but this is at least a little introduction to them.